Welcome to the Green Margin Podcast, where we talk about the financial and operational realities of running a cannabis business. I'm Daniel Sabet, and today we're going to talk about the legal and regulatory side of the cannabis industry and how operators navigate an environment that continues to evolve rapidly. From licensing and zoning to intellectual property and federal rescheduling discussions, cannabis operators are dealing with legal challenges that touch nearly every part of their business. So today we're going to talk about how law firms are helping operators navigate the cannabis industry as it continues to mature. Joining me today is Sam Porter, partner at Ice Miller, a law firm with a significant presence in the cannabis industry. Sam works with cannabis operators across a variety of areas, including intellectual property and trademark matters, lobbying efforts, real estate and zoning approvals, and the broader regulatory strategy. He's also been involved in conversations surrounding the recent federal rescheduling developments and works with clients across multiple markets, including Ohio and Indiana. Sam, thanks so much for joining me today.
Daniel, it's a pleasure. Thanks so much for having me and looking forward to a good discussion with you on all things cannabis and the ever-changing landscape that we have here across the United States.
Absolutely. Yeah, I've been in this business for over 6 years now, and every year something new happens, new states open up, new regulations come out. So excited about this conversation. So let's start with the work your firm does in the cannabis space. Cannabis operators deal with legal issues across a lot of different areas. From your perspective, what are the primary services Ice Miller provides to cannabis businesses today?
Sure. A little bit about Ice Miller. We're a full-service law firm. We're predominantly in the East Coast and the Midwest. We're about 350 lawyers strong. Our presence is New York and Delaware, Maryland, Indiana, Ohio, Chicago, Washington, D.C., Philadelphia, just to name a few. But when it comes to our cannabis practice, Daniel, really our bread and butter is regulatory compliance. It's on the corporate and business side. It's on the licensing side, and then financial services and banking. We also help our cannabis clients with data and privacy security issues, environmental issues with maybe the land that they're purchasing, food and agribusinesses, government advocacy, which we'll get into, which is a big part of what I do, some healthcare, intellectual property, labor and employment, litigation, real estate, taxation. Honestly, it's the full gamut that we touch on and have been very successful for our clients.
Very good. And out of those different areas of law, where do you typically see operators needing the most support?
So it's interesting. I've been doing this for just about as long as you have. And it really has been an evolution over time for the past 6 to 7 years. Our firm started off on the litigation side, and we saw challenges to the licensing structure where individuals were applying on a merit-based system. And maybe they were just close enough to being awarded enough points to get their cultivation or processing facility, but failed to meet the mark. And we got involved from a litigation perspective to help people show that perhaps there were fallacies in those systems. You go from once that tangent over to what we saw as a land grab phase. And what I would describe it as is like when operators were trying to just get as many licenses as possible. So we were helping clients navigate the landscape across multiple states in the United States to help them get licenses. And then we moved heavily into the regulatory space. And now that these individuals had won licenses, maybe through litigation or merit-based or raffles and drawings, not raffles, but drawings, lotteries, we're helping them get open and operational. And it's trying to understand the state regulatory systems that they're in and just for them to figure out what is it that I need to do to get open and open as quick as possible. One other thing that's important for me to share is that our firm were the lead drafters of Issue 2. Issue 2 was a ballot initiative in the state of Ohio in order to regulate and legalize adult use recreation. So we had medical marijuana. And to be honest, our state leadership, the governor's office, the Senate president and Speaker of the House, they weren't interested in moving to a rec state. And so a mechanism called a ballot initiative where we can, citizens, make a change to the statute and that can become law once it's passed on in an election. So a real difference is, and we don't need to get onto it this call. I know we have limited time, but there's a legislative or a statutory ballot initiative and a constitutional ballot initiative. And we discussed it made political sense to do a statutory ballot initiative rather than a constitutional change. So it's an effort. You want to think about what is important, what do people want, but what's also passable when it comes to November. So we helped get that passed in November of 2023. And then throughout 2024, helping to get people up and operational. But in addition to litigation and to real estate and to regulatory compliance, we've really come on strong, Daniel, in the M&A space. So helping people buy and sell licenses. So I mentioned the lottery processes, that there was an RFA2 process, and it happens in other states too, where maybe just people that are very interested in getting into the industry apply for a license, and maybe they're mom and pop type places, and they just don't have the level of sophistication to run an ongoing dispensary or manufacturing or production. And so they're like, you know what, this really wasn't the best idea, or I can make a lot of money. So they're looking for ways to sell that license, and we'll help connect them with people and sell. So we've also seen an uptick in trademark work, labor and employment issues as operators continue to get more settled, and then tax structurings, and then things like ESOPs as well.
Yeah, that's an interesting take you have on the M&A. I mean, a lot of my clients, even when they first start, their goal is to sell. It's just getting to that point. It could be 5, 7 years down the line. We even assist them with the tax structure of, for example, if they're a C Corp, they can get that 1202 small business stock exemption after 5 years if they sell the business. So a lot of times in their mind, whether it's making money or not, they have this thought of, let me build it up the best I can, and then let me have an exit plan. And even if they don't exit, just having that exit plan that someone comes by and gives them a grand offer they can't refuse, they're set up properly to take on that offer if they choose to.
Yeah, that's smart. That's so smart. And it's great that they've got resources like you and your firm in order to set that up.
Yep, absolutely. Now, let's touch on the intellectual property and branding for a sec, because that's one area that continues to grow in importance from what I've seen. As this industry becomes more competitive, companies seem to be putting more of their emphasis on protecting their brand. From your experience and just your overall opinion, how important is trademark and IP protection for cannabis operators today?
So I would say trademark and broader IP protection, it's become strategically more important for cannabis operators because the industry is shifting. And I mentioned that sort of land grab type paradigm into more of a mature consumer packaged goods market. So as competition increases, the companies that survive are often the ones with a recognizable brand, the proprietary products, or the defensible market position, not just I've got the most cultivation capacity. I've got the most dispensaries across the state. But a few major reasons why IP matters so much, I'd say, is first is brand differentiation. It's becoming more critical. And the craft beer market, as it started off, I felt like there are so many different craft beer brands. How do I know what I like? And then just over time, the market settle a little bit more. And the more reputable brands are the ones that are here today. Cannabis products, can become commoditized quickly, especially in mature markets where flower quality and pricing, they really begin to converge. And maybe you've seen that. But strong branding helps operators distinguish themselves. It builds trust. It builds product consistency. Sometimes it's lifestyle positioning. And then they have pricing power as well. So operators, they're investing heavily in their logos and their packaging and strain names. Sometimes it's retail experiences as well. When you go into a dispensary, how do I feel? What's the experience like? And then customer loyalty, because these assets create long-term enterprise value. It also helps prevent copycats as well. So the industry it's got widespread issues with imitative packaging or similar strain names or counterfeit products, and it creates confusion. But one of the challenges, though, is that in the United States, is cannabis, it's there isn't the federal structure here. So cannabis presents an unusual trademark challenge where because cannabis is federally illegal, and we'll see how restructuring changes the way the federal government looks at trademark issues, but you can't get a standard federal trademark protection to the US Patent and Trademark Office if you're plant touching. So the solution has been, and by the way, I should give a shout out to Jackie Lesser. She's in our Philadelphia office, and she handles all of our cannabis trademark matters. And happy to connect you, Daniel, or your clients if you have questions. But what she's found, and working closely with her, is there's a layered strategy here, and you can do a state level trademark. You could do a federal trademark for ancillary goods like your clothing, accessories, and whatnot. There are copyrights for packaging and creative materials. Sometimes there's trade secrets for genetics or formulations. And then there could be patent filings where applicable, but she really would be an excellent resource for you or any of the listeners that are interested in that. I touched on just very briefly, I'd mentioned what would happen with the rescheduling. One thing to think about too is interstate commerce and in future legalization. Many operators are preparing for the eventual federal reform or interstate commerce. So companies may secure branding rights at an early stage. It could give them a substantial advantage when the national distribution becomes possible. So that's just something to think about as well is, hey, maybe I don't really need it for this or for that, but change is likely coming. So overall, Daniel, what I would say is just trademark and IP protection. They're no longer just optional for serious cannabis operators. They're becoming foundational business assets. They're tied directly to their valuation, expansion, and investment. So for some of your clients too, that could be part of the sales package that they're creating is they're looking for an off-ramp.
Very good. But let's shift over to the real estate and zoning aspect of cannabis.
Yeah.
I guess from your experience, how difficult can the zoning and approval process become for these cannabis businesses? And what are some of the biggest challenges operators run into when they're trying to secure that compliant location?
Sure. And I'm smiling here where you think you've done it. You think you did the hard part. You won. You got a license. Or congratulations, you just fought off litigation. You got yourself a license. Oh, now what happens next? So you're going to be very much aware of the state regulatory regime and what you're going to be required to do to get open and operational. But oftentimes, you're going to be required to have local zoning approvals or confirmation that you have site control. It just opens up a massive can of worms. One, misinformation. The locals are sometimes last at the table here. They don't know what's going on. During processes, they've said, "Are you sure recreational marijuana is even legal?" And I'd be like, "Yes, it is. Here's the law." And they'll be like, "What about the regulatory structure?" And so we'll have to educate too sometimes with them. So they are skeptical of opening the door to a dispensary, let's say, or a different type of operation if they're not educated enough on what the business is. And also, let's be honest too, cannabis is a little taboo. So you might have folks, you may have fought and won against the state bureaucrats to get it legalized, but you might have local pushback too. And those, they may say, "Hey, we need a local ordinance. Y'all are not allowed to come in here yet." Or we've got a moratorium and it's a limited moratorium, but until we figure some more out, you can't come in here. And there's a significant amount of moratoriums that still exist in states and like Ohio that are roadblocks for people. So another challenge is when we talk about education, it's hard for folks to find this information online. So you you might not have a law firm like Ice Miller or counsel that can help you find the ordinances or the regulations because they may not be online. So you might have to call and then always confirm an email if you can so that you've got a record of who you spoke to. Because sometimes you might catch somebody, an operator, and they might give you advice, and it's really not coming from the person that has the authority to say such. Another look, as you mentioned, you might have to have a variance. You might have to go through the zoning appeals board. You might have to have a conditional use permit. It's just there's a lot of issues when you get down to the local level. So it's important that you're well organized. Another roadblock we see too is, okay, great. I understand the limitations that I might have of where I can place my dispensary. And you're working to get your paperwork together, but then you realize, you know what? They limit the number of dispensaries that are in the town. It's not that Okay, I'm not within a mile of another dispensary. I'm not within 500 feet of a church or a park or a school. But you know what? I'm late to the game, and there are now three-person in line, three dispensaries in line before me. You have to move quickly, and you've got to have the right resources and flexibility to be able to move quickly.
Yeah. So interesting. And it seems like you go through all these hurdles, but then once you get to the finish line, you're just sitting pretty because now the other people behind you have to go through all this as well and just eliminate some of that competition.
Yeah, and you know, I will say this, some folks do have sharp elbows. You always need to be on the offensive and make sure that what you have is defensible as well and are protected.
Yep. Now, your firm has also been involved in lobbying and broader industry advocacy efforts. What role does lobbying play in in the cannabis industry today?
Yeah. So I think this is just critically important. What we stress on is we really understand the intersection of law and politics. And I think it's critical to understand the political landscapes of the jurisdiction that you operate in. And it's not just about local, state, and even federal level issues. It's about relationships too. And it's about relationships that you're building with staff, relationships you're building with the decision makers as well. In our firm, we are advocates. We meet with local trustees, state officials. We've even met with members of Congress on these issues. But it's not solely just about trying to get a bill or a law changed or drafted, but it's these relationships and to help educate because there's so much misinformation out there, and we try to help bridge those gaps. But the political piece is important. And I think that's why people hire us. It's not just because we're good lawyers and we can help move the needle on things, but when there are political challenges, we can help you navigate those.
Very
Take
good.
for take for issue two, for example. That was a reason why we were hired too. We could put the law together, but help get it passed at the same time.
Yeah. And I'm sure all the Ohio operators have to thank you guys for that because I've had a handful of clients who came in around that time while they were still in medical space, and they were just set up perfectly for when that change happened, that they could expand their client base through recreational. So I'm sure they have you guys to thank heavily for that.
I appreciate that. I appreciate that.
Yep. There's obviously been a lot of discussion recently around potential federal rescheduling. Obviously in December we had the executive order, and then recently about the medical being rescheduled, and I guess we're waiting until June to see if it goes retroactive and if recreational is next. From your perspective, what actions has your firm taken in response to these news?
Yeah. Just like everybody else, we're reading the order, trying to understand it, trying to understand what it says, but most importantly, or just as importantly, well, what doesn't it say as well? It's not in there. We've reached out to our state regulators and other jurisdictions as well. We want to know their reaction to it. What efforts are they going to take? If there's any guidance they're going to issue, how might they be implementing it? You've seen in Oklahoma, there was a directive from OBN that said that if you're a licensee, you have to get registered. Directions from California on this just came out recently as well, giving advice to folks as well. It's important, not just what the federal order says, what are your state regulators stating as well? So, an example of what I said of what does it say, what does it not say, it appears to just address medical marijuana, as you shared, Daniel. Ohio, for example, has a dual use license. They got away from the MMCP license and you've got a dual use license. And so, how does that affect maybe your tax filings that you're going to make? So, we spoke to the regulators. Like they're willing to be a great partner to be helpful. Maybe there's an opportunity for them to reissue you a license if we think it's needed. But we consult with our clients, we consult with our colleagues on this to hear what they're hearing. I would think Most people aren't asking us so much as what should we do? Should we file? Should we not file? They're more asking about what we're hearing and the information that's out there, just because folks are waiting on additional guidance, hoping that there's additional guidance from the DEA that comes out prior to the hearing that you mentioned. But most people are making their own decisions. But the discussions that we had, Daniel, are about potential restructuring for operators. As we were just talking about, the order just talks about medical. So what happens with the rec license? Do we need to pull those apart and separate them and have them in a separate entity of a business? And then there's also, okay, maybe we made that decision, they made that decision, but oh shoot, there's regulatory hurdles with your state regulator. And what are the challenges going to be if you need to file a change of ownership? So there's a lot of moving parts right now. The best advice I can get is to consult with not only a legal counsel on this, but your CPA, a good firm like Green Growth, to discuss with you guys, what does this look like from an economic standpoint for my company, and what impact would it have on taxes and banking?
Yeah, absolutely. I think this year we've had the most extensions for taxes than
Hmm.
in any other year that I've been around, and I think mainly it's a sit and wait game for them. A lot of the clients, they're gonna pay their estimated taxes. They're gonna pay based on the draft that we provided to not using 280 or actually implementing 280 to say this is how you guys have been paid taxes in the past. They're paying those amounts based on that, but then obviously once we actually file it, if we file it closer to the deadline, if they see that they overpaid, we would just apply those payments toward those estimate payments for the rest of the year. They're hedging their bet there a little bit. They just want to see what comes out the next few months. So it's gonna be an exciting summer for sure.
Get your popcorn, right?
Yeah, get your popcorn ready. What are some of the most common legal or regulatory mistakes cannabis operators make?
The cannabis market is maturing, and the focus really has been about getting a foothold in your market, securing capital for survival. And by no means have those issues been resolved. But you've got regulators that are maturing, and they're starting to better understand how to regulate cannabis industries. And with that comes changes in policies and regulations that you may not be ready for. Maybe you've already gotten comfortable with the original paradigm and things are moving. Cannabis regulation is not just a legal issue, it becomes for your business a margin issue, a staffing issue, a forecasting issue, and increasingly a survival issue, because the businesses that are succeeding today aren't necessarily the businesses with the best products, but they're those businesses that can operationalize compliance faster than their competitors and move with the changes that are happening quickly. So as cannabis markets and operators mature, the companies that grow towards a culture of compliance, I think, are going to succeed. An example of this I've seen is an operator that was a multi-state operator, and they have a singular marketing department. They may have a marketing campaign that is great, and maybe it works in an open state like Colorado or California or something like that. That marketing campaign is not going to work in Ohio. It's not going to work in Pennsylvania or other tightly regulated spaces. It's about almost understanding compliance, and everybody's got to understand compliance for all the sectors of your business.
Very good. Now, before we wrap up, what's one thing that operators should understand from a legal and regulatory standpoint before they get too far down the road?
There's a lot of opportunities to make money in this industry, and there's a lot of opportunities to make mistakes as well. When you consult with your clients, there's high cost to entry and holding your footprint as well. And a lot of that comes down to taxes too. That's certainly an important component that you've seen. But you've got to consult with the best experts you can find. You need to get as many opinions as you can and listen to those. And I think that it's going to take patience. It's going to take a well-developed plan, and it's people that you can rely on.
Sam, thanks so much for joining me today. And thank you everyone for tuning in to the Green Margin Podcast. We'll see you next time.
Thanks, Daniel, very much.